Okay, another tort that is against economic interest is unfair competition. And unfair competition is a situation where somebody's maybe not even trying to make any sort of profit, but they are charging very little for their product or service in order to drive another company out of business. So they are trying to make it so you can't possibly compete with them. That is what we would call unfair competition, and they can sue on the basis of that. Another tort against economic interest is fraud or misrepresentation. This is when somebody uses deceit, so they have to actually be lying to you or, trying to deceive you in some way. It has to be a material fact. Whatever they're talking about has to be a fact, not just an opinion, and they have to be doing it for personal gain. So as long as you have those three things, you have fraud or misrepresentation. They don't necessarily have to know that it's not true. We again use that standard that they either know or they have a reckless disregard for the truth. So they didn't even make any attempt whatsoever to know whether or not it was true. That would be enough to rise to the level of fraud or misrepresentation. A lot of times we see this in insurance claims. People will make a claim on their insurance, and perhaps they will make some statements that aren't exactly true so that they can get a bigger payout or maybe a payout that's not due, and that would be considered fraud or misrepresentation. There is an exception though. We do want to watch out for situations that we call puffing. Puffing is considered okay. So if a company just sort of exaggerates about the quality of their product, in a way that you would expect a company or a person to do because they're trying to sell you something, we're not going to call that fraud or misrepresentation. So when Papa John says better ingredients, better pizza, it's sort of an opinion. It's sort of, we know that they're trying to sell us their pizza. So we're not going to say, oh, wait, that pizza's not actually better than Donato's pizza, so therefore that's fraud or misrepresentation. So puffing is okay. Another example, Folgers, the best part of waking up. I mean, something they probably can't even really prove is true, right? But you're not going to be able to sue and say that is fraud or misrepresentation. We would call that puffing. You see this a lot with salesmen. You might have a car salesman who's trying to sell you a car and they're telling you how great it is. But we expect that, and we would call that puffing. Now, a lot of times we see fraud or misrepresentation in the form of false advertising. One of the cases where we have seen this has been a really big case, is where Blue Buffalo is a company that published all these results about their dog food and how great their dog food is. And they tested it against all of their competitors. And of course, if you do that, your competitors are not going to be happy, right? So they're going to look hard at that. So Blue Bonnet published this, and they said that they didn't have any kind of meat fillers or whatever. Well, Purina bought some of Blue Buffalo's dog food and had it tested, and actually found out that there were some fillers in their dog food, so that this was not actually true. And they sued Blue Buffalo for false advertising as a result. So advertising is an area where we do need to be a little bit careful, and we want to make sure that what we say is true. I don't know how this lawsuit is going to turn out, but you want to be careful because you don't want to even face the chance of being sued because that is an expensive proposition. So do be careful with your advertisements. All right, so these are our 4 intentional torts against economic interest. Disparagement, which remember, is like defamation, like slander or libel. Intentional interference with the contract, unfair competition, and then finally, fraudulent misrepresentation. So the final thing I want to talk about are damages. When you are sued for a tort, you face the prospect of compensatory damages. Compensatory damages are anything that will compensate the other party, put them back in the position that they would have been in otherwise. So we're going to look at things like, do they have any medical bills? Do they have lost wages? Did they have pain and suffering? Do they need to repair damaged property? Are there lost profits? The only thing that we do not include in compensatory damages that you might think we would be attorney's fees. You cannot get attorney's fees as part of compensatory damages. Now, on occasion, a jury might say, yes, we think a tort occurred. Let's say you were assaulted. So you had somebody who threatened physical harm. You might sue, and they would say, yes, there was an assault, but you don't actually have any damages. They never hit you. You didn't have to go to the hospital. You have no medical bills. There's really nothing that we can compensate you with. There's no money we need to repay you. So we're just going to give you nominal damages. If the court just gives you nominal damages, you're going to get a very small amount of money, maybe $10, $20, something like that. And all they're saying is, you didn't really have any damage, but we do agree that you would win this case, that you are in the right, but you just don't win anything. With nominal damages, we do allow you to get attorney's fees. So you would be able to get your attorney's fees, but that is the only thing that you could get compensated for. So no attorney's fees with compensatory damages, but you can get them with nominal damages. Now, if you've had compensatory damages, you may also get punitive damages. You can't get punitive with nominal, but you can get it with compensatory. Punitive damages are designed to punish the tortfeasor, to punish the person who committed the tort, because whatever they did was so outrageous and so wrong that we don't want people to do it again. We want to send a message. So we put these punitive damages. You've already been compensated for all of your loss. You've been made whole again. But in addition to that, you get additional money, and it's often a big number that is just really designed to punish the other party. So it's sort of a windfall for the person who is suing. This is one of the areas where we were giving out a lot of punitive damages, and about 20 years ago we began to really restrain the amount of punitive damages that people could recover. So now at this point, courts really look at punitive damages and they say, are they more than 9 times the amount of compensatory damages? So for example, if you got $100,000 in compensatory damages, you could only at the most get $900,000 in punitive damages. Anything over that, the court is really going to say that's probably excessive. So we're kind of looking for that 9-to-1 ratio between punitive damages and compensatory damages. And then the final thing I wanted to talk about is small claims court. Small claims court is just an easy way to file a suit if you feel that you have a claim but it's not very much and you don't really want to hire an attorney. This is a great way to do it. Small claims court is just in every county. You would go down to the Franklin County Courthouse, for example, and you could file a claim there. You can also do it online, and it's very easy. Just Google Franklin County Small Claims Court, and you'll be able to get the form and fill it out. It's a one-page form. You fill out what has happened and what you are complaining about, what you are suing the other party for. You don't go through all the normal process of having to have a complaint and a subpoena and all of these things. In fact, in small claims court, you do not even have to have an attorney. So you can just do this all yourself. But the trick is it's got to be less than $6,000. So that is your limit on what you can sue for in small claims court, $6,000. The great thing about it is that if a corporation is in small claims court, if you sue a corporation, most of the time they're going to want to have an attorney because they have restrictions on them if they do not have an attorney. So they're probably going to hire an attorney. And that's going to cost them some money. It's probably going to cost them $6,000. So a lot of times a corporation will feel very encouraged to settle with you because they do not want to have to go through this process. So it doesn't always work, but if you had a small dispute with someone or with your landlord or something like that, this is a great option to be aware of. So I just like to make people aware of it. So there you go, $6,000 limit, no attorney necessary, and it's something that you can file online.